Good afternoon. This is Camille Crary. I am the Director of Legal Services and Policy at the Ohio Alliance to End Sexual Violence. We are so thrilled to be here today. Our legal team has spent the last several days analyzing the Title IX final regulation and really the last couple of years analyzing the proposed rule and the impact and potential impact on survivors and on campuses. So we feel like this has been a long time coming and we've been preparing for quite some time. So I just want to go over a couple of technical points before we get started with the webinar. This is a 3-part series. So for those of you that joined us in November, December, and January of 2018 and 2019, when we were working through the notice and comment period, we did a 3-part series then as well. And so we felt that that format, based on our feedback from our members, was the most effective way to communicate this information. And so our plan for the next several weeks is to host a webinar today for 2 hours from 1 to 3. We will host a webinar next Monday for 2 hours from 1 to 3. And then because Memorial Day falls on the 25th, we will engage in a final webinar on June 1st from 1 to 3. For today, much like when we did these for the notice and comment period, our preferred format is to pose questions at the end. So we've listened to several webinars on this topic, and we have found that it's most efficient in our minds to do the questions at the end of the webinar. And that gives all the participants the full length of time for us to cover topics and simulate or formulate questions and pose those at the end. So I do want to highlight that we will do an hour and a half of content and then a half an hour of questions today. Next Monday, we will do an hour and a half of content and then a half an hour of questions. And then our third webinar, we presume, unless something changes, will mostly be questions and answers. And during that period of time, we will also be publishing a guidebook that is very similar to the notice and comment period citation guidance packet that many of you received during that period of time as well. So we will be providing that to folks who have accessed registration. We'll be instructing you on how to get a copy of that in the coming weeks. So today we have our whole legal team. Myself, I'm Camille Crary, like I said, the Director of Legal Services and Policy. Kendra Roberts is our LAV attorney from the Ohio Survivor Legal Assistance Clinic. April Carter, the Ohio Survivor Legal Assistance Paralegal. Becca Getson and Chelsea Daniel are campus and legal advocates for OAESV. So we have a lot of different perspectives. I will be giving a brief history of Title IX, and after that, Kendra will go into some of the nuanced provisions, and Chelsea, April, and Becca will be providing context from an advocate perspective and from a K-12 perspective. So Kendra, if you would like to push the next button, I will go over our objectives. Thank you. So today we're going to talk about the newly approved Title IX regulations. We will consider the effects of these regulations on survivors, advocates, and attorneys. And we will also be able to identify practical opportunities to use these newly approved regulations to support survivors. And if I can have you hit the next button. Thank you. So, excellent. And I know that a lot of you have joined us on many of our presentations. So this question might be repetitive for some, but I think it's a really important foundational question. What is Title IX? We see the phrase Title IX, the term Title IX in many respects all over our content area and in conversations with the people we serve, on television, in the news. It's a big thing, but do we know exactly what it is? Under the law, there's court precedent, there are federal legislation, constitutional amendments, and federal regulations that impact our day-to-day life. And so Title IX is federal legislation. Federal legislation meaning that it was initially an act passed by Congress, which means that it was a legislative law that was signed into law by the president. And so this law is very significant and every aspect of sexual violence for our advocacy and for our survivors every single day. And this law was passed in the 1970s. The long title is actually longer than the text of the law, which I find very fascinating, but the longer title is several words long, and so we're going to stick with the short title, which is Title IX of the Higher Education Amendments of 1972. And this was signed into law. We can hit the next slide. And what it states, like I said, the long title is longer than the law. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or if we can head back to that slide, sorry. Just having a couple technical difficulties. While we are working on that, I will pull up my own on my computer, but essentially what it says is no person in the US shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So right now, as it always has been, there are two ways to enforce Title IX. The first is civil litigation. The second is administrative enforcement. And what I want to highlight for all of you is that the civil litigation prong of this has not changed. So the legal standards for persons filing a lawsuit are exactly the same today as they were yesterday and the day before that. They are the same that they were when Barack Obama was president. And so what we're really focusing on right now is administrative enforcement. And what I mean by that is that when Richard Nixon took a look at this particular very vague law, no discrimination on the basis of sex, he said, I don't really know how to interpret this. He felt it was too brief for meaningful interpretation. So he ordered what was then in existence called the Department of Health, Education, and Welfare. And I just want to note that the Department of Education wasn't formalized until the 1980s. And for that reason, this other department produced the regulations. And they codified those into the Federal Register in 1975. After that, Bill Clinton, his administration reinterpreted, looked at it, thought, it's been over 20 years. We really need to investigate this more and make sure that we are making these things current and up to date. So Bill Clinton's Department of Education published sexual harassment guidance, harassment of students by school employees, other students, and third parties in the Federal Register. And then in 2001, George Bush's administration took a deeper look at that, specifically because there were two cases, Gebser and Davis, that were issued by the Supreme Court of the United States. And those cases discussed, and it was interesting because those cases came about in the 90s. And if we can pause the webinar or the PowerPoint presentation to make sure we're on the right slide. I know it may have just started playing. Sometimes they do that when they are in slideshow mode. But with the Bush administration guidance, they had looked at the first real case law that discussed Title IX for the Supreme Court. And so what was notable about Title IX was that Congress really didn't set standards that the courts had to follow, which left the courts describing what they had to do differently. And so those courts went in and said, look, the purpose of court precedent and the purpose of administrative regulations and guidance are two very different things. So we are going to use stronger standards, specifically deliberate indifference, which you'll hear a lot about later from Kendra, is a stricter standard, and the reason for that is that if they gave monetary damages to every person who violated the administrative regulation standard, school districts would go bankrupt and there would be no public education in this country. So that's A, a bad sign, but B, reflective of the purpose of civil litigation, which is to make someone whole, and unfortunately, monetary damages are the tool that we generally can use for that. So the commenters agreed after receiving notably only 15 comments guidance during the notice and comment period, which is drastically different than the 124,000 we received this time. We needed the administrative remedies to stay the same. And so Justice O'Connor said, the goal of an administrative remedy is to make schools better. And so we're going to allow a lower standard of culpability for an administrative investigation. So they issued guidance in 2001, which was actually the basis of the Obama era guidance. So we can, I can move on to that. Obama published the Dear Colleague letter in 2011, and I do want to note the Obama administration was the outlier here. They were the first administration that did not publish in the Federal Register, so the process did not go through the notice and comment period, which made very drastic changes. And for those of you who work on college campuses, you know that that was very likely a very difficult change to make without having the opportunity to provide feedback. But I will say that, like Clinton and Bush before him, he did build on prior regulations. And so they expanded upon the 2001 revised sexual harassment guidance. So when I was doing Title IX practice, I typically referred back to the 2001 guidance because there were not situations in my experience where those two things conflicted. It was just the 2011 gave more specificity. And then after that, we had a very brief period of time compared to the 2001 guidance. And in 2017, in the fall, the Department of Education rescinded the Dear Colleague letter and instituted interim guidance. So this proposed guidance was issued on November 16th, 2018. Over 120,000 people, many on this call, engaged in research and writing and advocated for changes to that proposed rule. And then they finally released the final rule on May 6th, 2020. So that rule goes into effect on August 14th, 2020, which is a very quick turnaround time in my opinion, and means that schools have to work very quickly on making those changes, especially considering that we're in the middle of a pandemic. So now that we have the rule, I'm going to hand it over to Kendra, and we're going to discuss the major changes and distinguish from the proposed rule. So we spent a lot of time working with the proposed rule and previewing what was very likely going to happen because our sources were accurate in saying that there would be very few differences. So we're going to look at some definitions today, changes of location, timelines, and procedures. We're going to look ahead to risks for survivors, advocates, and attorneys. And then we're going to, like I said, at some point in the next couple of weeks, issue written guidance for all of you, and then we'll have 2 more webinars. So any features of this proposed rule that we don't get to today, we will get to in sequence, very much like the notice and comment period webinars. And with that, I thank you for your time, and I will hand it over to Kendra Robert.
Hi, everyone. So let me see. All right. So as Camille just said, we've got the new rule, and she's very correct in saying that it very much mirrors in many ways the proposed rule that most of you have probably already seen at least bits and pieces of. So that's not a shock to us, but now that we have the actual rule, we can start to think strategy, right? And so we advocated for what we thought should happen. We ended up with what the new rule says, and now it's time to think, you know, what do we do in practice that will use this new rule in every way we can proactively, so to our benefit, and then also how do we defend against potential downfalls of the new rule. So first of all, in finding it, anything you want to see, Title IX publications, all of the previous guidance is on there. They're undergoing changes on the OCR website right now, and so it seems to sometimes have all of the OCR decisions that have been made before on there, and then other times not. But there are contacts for your local OCR offices, and if you go to that first link there, and these links should work when we send you the PowerPoint. that's where you're going to find the actual guidance. That is what that first link is, the regulations. They do give some other items, and some of them are more helpful than others. If you don't want to read the entire 2-page document in all of its glory, that fact sheet is not particularly useful. I wouldn't waste your time on that. That is very much a statement from the president about how survivor-centered the new regulations are going to be, and we'll talk about that in a moment. The final rule overview is helpful, but I would say for all our purposes, if you're going to choose just one thing to read over after this webinar, I would read that first, that summary of the final rule. It's going to point out specifics. And the OCR webinar is helpful. I would say that it's pretty brief in that it does include all of the significant changes, but it certainly doesn't speak to strategy, and it also seems to focus on points that are probably less important to us. But as a refresher, I would probably pinpoint that and go back to it if needed. There are probably some pretty good slides on there that you could use information from. And then they tell us that we can send questions to them at this email address. I have not done so yet, so I don't know who it is that responds and what those responses look like, but apparently if you have any questions, you have an open forum at open.egov to ask away. All right, so before we get into the actual language, actual changes in the new rule, I thought we should frame our minds and things to expect. So as we're going through the new rule, what is it? What are the themes? What are the things we keep seeing? And what can we read between the lines and see that perhaps the intent of the overall new rule is? You're going to see a lot of language in the beginning of the rule and in all of the Department of Education's explanations of the new rule, kind of the why they gave us this new rule, is that it is, they pronounce it as the first time it is in the rule of law. As Camille was explaining earlier, that is because previously we were going by that dear colleague letters and the interim guidance pieces. And so now, we have this new regulation. That language to me in many ways seems to be unnecessary. I think it is a pronouncement to those less familiar with Title IX to be, impressed that the Department of Education has come up with an entirely new law. In practice, I think that's going to have very little impact. There are already court cases on the guidance and on Title IX in general, and I think that those are going to stand. The courts are going to continue making rules and ruling on specific instances. So I don't think in our practice in the day-to-day Title IX with survivors in campus that we have to be concerned that it is now the rule of law. That is going to become more relevant in the OCR, post-OCR processes. You can expect, however, probably respondent attorneys to use that language, that rule of law language, to advocate for things they do or don't want to happen throughout the process. They also use a lot of language, so a lot of the changes from the proposed rule to this is to include some survivor-centered language. They talk about the main goal being, to protect survivors on campuses from sexual harassment. You can assess for yourself whether you think that goal will be met with the new rules. The problem I see, of course, is that while this language is included, the changes don't actually typically benefit survivors in any way any more than respondents. It seems that if there are changes and if they are going to benefit one party or the other, it seems as though in practice they would benefit someone accused of sexual harassment or sexual misconduct rather than someone reporting that. But I think that all of this language is something for, or something that attorneys, particularly probably respondent attorneys, will cite to when perhaps it is the complainant that has a problem with the process or how they were treated. In response, probably they are going to cite to this language to say, well, you know, the goal of these regulations was to protect survivors, so it does protect survivors, so whatever happened was okay. Also, there's a clear theme to cut college kids some slack. I'm not going to say that it is to cut one gender or the other some slack, but there is certainly a theme throughout that that college kids are just college kids, right? And so they may not be a responsibility of the school to hold them accountable as much as we may have thought or we may want to see. You know, I won't say boys will be boys, I will say college kids will be college kids. Seems to be the theme. And so, and we can talk, I'll point some things out as we go through the changes of examples of that, but expect to see that we're trying to really, it seems that they're trying to really reframe who the accused are in Title IX cases as just college kids. There is a significant focus on the right to free speech and how important it is throughout the Title IX process, which is true. I would argue that the right to free speech is in fact important in, well, any process, but they really use that language over and over here. They tell us that the Constitution applies to the federal regulation in the event that we didn't think it may not apply. And you're going, and I will point these things out as well, you're going to see the free speech probably used as an excuse for, or any defense to allegations of harassment, particularly when it's language or probably written words, online postings. Some important things to think about, and we'll talk about the increased standard for how to even get to the harassment now, but one key point too is in retaliation. We'll talk about that later. They make it a point to state that you know, it is not retaliation to exercise your free speech. How that will be interpreted by schools remains to be seen. I think that there is a possibility, if we're looking at worst case scenario, that just saying inappropriate things or harmful things to or because of the complainant is not in itself retaliation because that person is just exercising their free speech. I also, again, here would expect that these pieces of language in the regulation will be those that are cited to again and again in defense of instances of harassment by respondents or their counsel. There seems to be, and this kind of goes along with the cutting the college kids respondent some slack, there seems to be a shift from punishment to process. So a lot of the guidance previously seemed to at least point to the need to, in keeping survivors safe, that would often mean that respondents would have to be held accountable, would have to be disciplined and fairly, extremely in some cases. I think the shift here in some of the things we're going to see throughout the process itself wants to push that back. So it wants to make punishment occur only when absolutely necessary, only when every step of the process is taken, only after the most time that can possibly pass has passed. And I think it's pretty clear that a survivor right to privacy or safety may not outweigh the respondent's right to free speech. in some instances, depending on how literally the text is interpreted by schools. One other new thing that we're going to see is the role of the Title IX coordinator. The Title IX coordinator has all the power. The Title IX coordinator is the only person who can do many, many things within the process. And if it isn't the Title IX coordinator that does those things, sometimes that's going to preclude a report of harassment from really being considered by the school. Arguably, that means that the Title IX coordinators are also going to be susceptible to more of the blame when things aren't going well. And they certainly have more responsibility throughout the process. And we will talk about those things. And then finally, and this is similar to the free speech theme, there is a theme, you know, we do know that the entire purpose of the original Title IX law was that discrimination could not occur on the basis of sex. The way that is used in the new rules is that again and again, there are snippets of language about how the responsibility, so whether or not someone is responsible for sexual harassment or sexual misconduct, cannot be linked to their gender. So the decision makers cannot presume that anyone is or isn't responsible for anything, cannot assess someone's credibility, whether they're lying or not, whether they are lying about consent or whatever it may be, because of their gender. I would presume that will be used by respondent attorneys to say, oftentimes respondents are males, oftentimes respondents, in my experience, are relatively privileged. And those things, those status things cannot be used against them. That doesn't mean that they were more likely or not to have done something. And if it is a male who is saying that there was consent and the female is saying that there wasn't, the decision maker should not presume anything due to that. A lot of those things, and we're going to see this thing too, is that many of these things are kind of things I say, of course, like, well, of course things. We already knew that. We already knew that the right to free speech exists. We already knew that, you know, that schools had to follow Title IX or face consequences. We already knew that they had a responsibility to respond to things. We already knew that they shouldn't discriminate on the basis of gender, but there is an attempt in the new law to really spell those things out again and again. And again, what mostly we're going to see with the use of that language is when things go, when one party doesn't like how things are going, in their case, they're going to use snippets of that language to advocate for the result that they want. All right, so Camille kind of already went over this, but today we're going to look at several of the changes that are in the new rule, not all of them. I can't possibly do it all at once, and I also think there's so much information that you wouldn't want me to try to do it all at once, though OCR managed to do it in less than an hour on their webinar, which is interesting. So today we're going to talk about kind of that initial, the initial changes around before a report is made and right after. This is, you know, so this would all be prior to an actual investigation into whether or not sexual harassment occurred. That we will cover next week. We will also talk about what happens after the investigation and then after the hearing through the appeals. I'm sure that some or all of you have heard about how one of the things that the new rule requires is that cross-examination not be direct, in that there's a right to cross-examination in hearing proceedings, but that the parties can't do it directly. They need to have an advisor doing that. We will talk all about that next week. We're not going to get to that point today. And we'll also talk about the decision makers and some of the requirements put on them And then finally, at the last time we meet will be, again, much question and answer, but we will by then have some definitive points and statements. So if you're in this situation, then we recommend you do this at that time. All right. So we're going to start with the definitions. There are some changes to the definitions. Some of them are not, most of them are not significant in that they don't change a whole lot of words. But the changes there, if you read into them, have potential consequences. So we have to really look at what was the intent on changing just a few words in this definition, because those writing the law didn't change words just because they thought it sounded better. When lawmakers change words in a law, it is because they want to be able to use or they want to give the opportunity for others to use those subtle changes to their advantage. So we do have, again, most school policies already did this, but we do have, you know, a lot of things can be sexual assault, right? And so, or sexual harassment. So sexual harassment can be actual sexual assault. It can be dating violence. It can be, they do call it dating violence rather than partner violence, but it can be verbal harassment. It can be actual sexual conduct, or actual penetration. Again, we already knew these things through school policies, but that is there. Quid pro quo. I'm sure most of you have heard about this in the context of sexual harassment. And again, I use the term sexual harassment over and over because, you know, it is that the way we are able to deal with sexual violence through Title IX is that instances of sexual misconduct and instances of sexual violence fall within the overall broad umbrella definition of sexual harassment. So if we're looking at the regulations, anything that is sexual violence is sexual harassment. And I know that when we think sexual harassment, we often think of certain kinds of conduct, but here I am talking about sexual violence and all of the other possibilities. So quid pro quo, I do something for you, you do something for me. It's Latin for something like that. I should have paid better attention in some of my early law school classes probably, but. So what this is, you know, a respondent cannot, so a student or a school employee cannot require or imply that it is required for another person to do something, provide sexual acts, or to say or do certain things, or to refrain from doing certain things as a trade, right? So I'll give you an A if you do these things with me. In the same way, and if it doesn't particularly matter here anymore, but quid pro quo could also be between even a student and another student on their team. So the captain of the football team cannot say, I'll let you get away with this thing if you do this thing to or for me. The new regulation takes the step to make it clear that that can only be between, so only school employees can commit quid pro quo harassment. The question then I think remains, so what we know is that one student cannot commit quid pro quo harassment against another student. There is no, according to the regulations, there is no power differential or power dynamic there that exists to make that into a quid pro quo situation. I think the question that remains is who's a school employee, right? So I think we're going to hear the argument that teaching the students, graduate students, may not fit into that definition. What about contract employees? I think that there are often, especially at smaller schools, professors or other teachers who sign brief contracts, and they are independent contractors with the school. So the question, I think the argument that we may hear is that those people also cannot commit quid pro quo harassment. I mean, I would hope that the response to that would be there is a power differential there, and so yes, they can. But I think we're going to have some case law establishing that down the road. The definition of harassment, I said it is broad and that they do include lots of different types of sexual violence and sexual assault that meet the definition of harassment. However, then it is more difficult to meet the general definition of harassment. So sure, it can be all these different types of conduct, but it has to be both sufficiently severe and pervasive. And so what is severe, what is pervasive, what is sufficiently? Pervasive obviously means ongoing or interfering. What is, how many number of instances and how significant does that conduct have to be pervasive? I don't know. And it also has to be objectively reasonable or offensive to a reasonable person. Again, we are going to come into the question of who is that reasonable person? Is it a reasonable complainant, a reasonable college-aged complainant? Is it a reasonable Title IX coordinator? And who's defining what is objectively offensive? Before, arguably, you would only need to establish one or the other, and now they make it clear that you need to establish that the conduct is severe, that it was pervasive, and that it was objectively offensive to some reasonable person, and that it, in effect, denied an individual of equal access to education. That denial word, I would anticipate, that's always been there, but there seems to be a focus on that. We see that again and again throughout the rules. I would not be surprised if the argument is made that an instance wasn't harassment because, and therefore can't be adjudicated through the Title IX process because it did not, because the complainant can't show how they were denied of equal access to education. I would argue in response as a survivor's attorney that any instance of sexual harassment does deny access to education in that it affects the ability of the survivor to continue pursuing the education in the same way that they were before the conduct occurred, but I'm only one lawyer on one side. And then we see an instance already of the intent for college kids to get some slack here. They differentiate between the requirements for harassment in the workplace and at college. So they say free speech is more important in the college context than it is in the workplace context. So you only have to show that you were harassed at work. You only have to show that it was sufficiently severe, pervasive, or objectively offensive. At college, you're going to need to show it was all of those things. I think the guise here is, and I think what in maybe previous language used, the argument was, you know, language used in class discussions or in class materials shouldn't be harassment when, and should be covered by free speech when, you know, it clearly wasn't intended to offend anyone or a particular person. I think here though, that freedom of speech pertains more to individual college kids. And as they're walking around campus saying the things that come to their mind, maybe locker room talk, that too is free speech, or may be considered free speech. All right. The harassment has to occur within education programs and activities. This kind of goes to the location point. So I think the intent here when in this section is again to limit the types of cases that can be violations, right? So of course, the school is going to address every instance of harassment. However, to meet the requirement that the conduct be harassment so it can even, the school can even consider it, it has to occur, not only does it have to meet this standard of harassment we already went over, but it also has to occur within education programs and activities. Again, I think the attempt is to shift the location on campus is closer to on campus rather than a more broad or general on campus location. The rule says that the school must have substantial control over the context of harassment and the person committing the harassment. The context is a worrisome word there because how the context of sexual harassment will be interpreted by schools remains to be seen. There's also language in there that it has to occur at a building owned by the school or officially recognized organization of the school, so like a Greek Life House. But obviously schools don't own nearby bars and restaurants or apartment buildings. I would presume the argument would be that the Clery Act definition of location of on and off campus should and will still apply because schools, number one, are familiar with that and pretty much go along with that. But I think there is some wiggle room in the new language for perhaps the accused attorneys to argue differently. But remember, again, schools can be more protective over survivors than the rules prescribe. They just can't give less, we think still. So arguably, if a school defines in its policies the things that will be harassment or where that will be harassment, they may have some leeway there as long as they do include and protect the things that are listed in the regulations. Before I go on to, let me go into one more here and then I'll pause. Another definition that's relevant is actual knowledge. So we've seen this before in that we know that they say the school has to have actual knowledge that sexual harassment has occurred before they have any duty whatsoever to respond to that sexual harassment, to try to redress that sexual harassment, to try to prevent future sexual harassment. And so there's already been disputes about what that actual knowledge means. It means that the school is, in order to be held responsible for violating Title IX, it has to be shown that a school acted with deliberate indifference. They were deliberately indifferent to the report of sexual violence. In order to have any duty, so in order to trigger that duty to respond to the sexual violence, they have to have had actual knowledge. That is limited here in the rules to, again, this power of the coordinator. So the Title IX coordinator themselves has to be the person with the actual knowledge of the conduct that could be harassment in order to trigger that duty to respond. It is not enough for other people in the Title IX office to, I would argue, to have actual knowledge. If that doesn't get passed on to the Title IX coordinator, that may be a problem with that specific person and not doing what their job requirement describes, but it is not going to be a violation of Title IX until the coordinator has actual knowledge. This is problematic because it seems to suggest then that not only other people in the Title IX office, if they know of something, it doesn't trigger this response, but what about athletic coaches? What about professors? What about anyone else on campus? It seems to be nope. It needs to be at least on campus, the Title IX coordinator. In the K-12 context, any school employee having actual knowledge of something that could be harassment triggers that duty to respond. This is that mandated employer impact on Title IX. If the school does not respond after the Title IX coordinator has this actual knowledge, then they can be deliberately indifferent. So what does deliberately indifferent mean? OCR is only going to find that a school has violated Title IX if they were deliberately indifferent and responding or failing to respond to a report of sexual harassment. Once that coordinator has the actual knowledge. And the way they assess whether they were deliberately indifferent is whether their response to that report of sexual harassment or their lack of a response was clearly unreasonable in the light of the known circumstances. Again, the known circumstances are not going to be the circumstances known by the complainant, not going to be necessarily even the known circumstances known by other professionals on campus. It's going to be what the coordinator knew. And if it was clearly unreasonable, that's a really high standard and it is really difficult to meet in court. And it is really difficult for OCR to find a school responsible for having been deliberately indifferent. And probably what is going to happen is that if the coordinator responded in any way to a report of sexual harassment, that's probably going to be sufficient. Whether or not they followed up, what exactly they said in that initial quote unquote response to the report, it's probably not going to matter as much as whether or not they simply did respond. Before I go on to the duty to respond, does anyone else, Becca, Camille, or Chelsea, have any notes for advocates specifically on the definition changes?
Hey, Kendra. Yeah, I wanted to share a little bit, just some initial thoughts and notes that we had. The first, I want to kind of backtrack a little bit on the Title IX coordinator piece, and we'll talk about formal complaints more later. But in terms of that approachability piece, so at the moment, most schools have a variety of people and various entities that can receive that information that will result in a report. And limiting it to Title IX coordinator, I just want to kind of give people a heads up that might have an impact on when and how people are going to want to report due to how approachable Title IX coordinator is, right? So just kind of making advocates aware of that, that how that happens might look a little bit different moving forward than it does now, just because of that, because there might be only one or two people on campus that can receive an official report. In terms of the definitional piece, I want to just kind of bring up from that advocate perspective that we're going over the definitions so that you know what they look like, you know what those changes are going to be, but that it's not up to us as advocates to determine if something meets that definition, right? And I talk about this a lot, but we want to make sure that everyone's aware of what those definitions are, what that looks like, what can be applicable to the different institutions, but keep in mind that it's not up to us to say whether or not it meets those, right? Are both met, or all the elements met in a case, all those kind of different things. You have it so you know what's going on, but also keep in mind too that depending upon when the rules come into effect, and because we know that there's a delay in reporting, what policy is going to apply to that student. So making sure you're aware of that as well in terms of what definition and what policy is going to apply when they make a report. So if someone decides to wait until September, but that it's about a January incident, those two different things might have different definitions that are applying to them. So just kind of be very aware of that. Another thing I wanted to bring up too, and something that Kendra kind of touched upon as well, is that we're really focusing on the Title IX regulations, right? So that's what we're looking at today. That is not to say that the schools may not have other code of conducts, other policies that might impact the same case. So even if it's not a Title IX case, if someone is reporting something to you and they're looking for additional assistance or support, it may not meet Title IX regulations, or it may not meet these particular 2020 regulations, but there might be other school policies or codes that can be impacted and that they might be able to utilize to move forward. The last thing that I want to make sure and bring up is that actual knowledge piece and how different and varied the institutional response might be based upon that particular institution, whether it's K through 12, college, technical school, whatever it is, whatever entity is applying Title IX, that institutional response may be very different depending upon the case, what kind of report they've received. All these things might factor in. So if you're working with a variety of students or employees in an institution, that individual response is going to look different. So for the most part, you may not receive the exact same response for a case. So just kind of be aware of that as well. When you're looking at a reasonable response to something, that reasonable response might look different for each case. So those are just a couple of things that I want to make sure I highlight, particularly for the advocates that are listening in terms of kind of where we are, what we're thinking about, and this direct impact on survivors.
Thanks, Becca. And I wanted to follow up on that real briefly. I thank you for mentioning, I probably should have done this at the outset, that not only do advocates not get to decide what deliberate indifference means, what actual knowledge means, what on or off campus means, neither do attorneys. We get to argue for what we think it should mean. We get to act in accordance to what we think it means, and strategize and represent a client because of what we think it means. But ultimately, the first person that's going to tell us what that means is going to be, what these definitions mean is going to be the school, right? Because it's their job to implement these regulations. And then ultimately it will be the Office of Civil Rights and the courts who tell us what these things mean, or what is sufficient to be actual knowledge, what is sufficient to be this or that. So that's important because I often, when working with advocates, I often get calls from them, particularly when we're initially discussing a potential Title IX case or a new Title IX case, and they will say to me very passionately and exasperatedly that this is sexual harassment. This is the school did not respond how they were supposed to, and pretty much 100 times out of 100, I agree totally that this should have been handled differently. But again, my response very often then, however, is I agree with you, except that what we think should be the definition, what we think should be how this thing is interpreted, is not how it actually is. Or so thank you, Becca, for mentioning that. I'm going to move on to the next step. And so the school's duty to respond, it's important to keep in mind that this duty is not triggered. And again, the other thing, when Becca said, there may be school policies and other things that affect this Title IX law. This is just one of the things we have to consider. You're going to end up obviously more familiar, particularly if you're working with one campus or several specific campuses, what their policies are, and their policies will probably even change to include some of this exact language. But I think it is important just on the peripheral to know what the regulations actually say, because it will help us when we're reading through those policies and trying to figure out what to do. Okay, so again, the school duty to respond is not triggered until the Title IX coordinator has actual knowledge of something that could be sexual harassment. So either they saw it themselves or someone told them about it. Once they do know, they have a duty to respond. They have to tell the, and they use the term victim in the guidance, or the regulations, and they define victim as the person who was supposed to have been subjected to the act that could be sexual harassment. So they have to inform that person, because again, it may not be that person who made the report, right? It could be another person who saw or witnessed it, someone making the report on behalf of the quote unquote victim. Maybe the Title IX coordinator saw the behavior themselves, or whatever it may be. Regardless, the person that was actually subject to it. So they don't have to respond to the third party who reported it. They have to respond to that person who suffered the instance. And they have to tell them that we can help you. We can provide supportive measures. We're going to go deeper into that in a moment. We could file a formal complaint, and if you do decide to file a formal complaint, then we could investigate this thing that happened to you and determine whether or not we should take the next step to determine whether or not an individual is responsible for what they did to you, and then if they are, we sanction them. But those are all coulds, because this report, as we're going to see, is not triggering automatically that investigation. That a formal complaint will trigger that investigation. We'll talk about that in a minute. So, but initially in responding, all they have to do is tell the victim how they can file a formal complaint, and then what that would look like, the right to a formal complaint or not to file. They also have to tell them that they do not have to file a formal complaint. Just because a report of sexual harassment is made, that person does not have to take the next step to trigger the investigation. And these supportive measures at this point can be offered by the school. What I think that's going to mean, though, is the school's not going to be required to offer any specific supportive measures to this person. And arguably, each supportive measure is individualized. So, like, every survivor is going to need different measures to support them, right? But because of that, I don't think the regulations put the school under any duty to offer specific supportive measures or a list of supportive measures. What they have to do is inform the victim that they can request specific supportive measures, but that burden of trying to get those measures put into place is going to be on the survivor. So when you're working with survivors, you're going to have to work with maybe even before the report is made, work with what do they want to ask for from the school and what would make sense for them in the event that you're working with a school that is not going to help walk them through that. Many Title IX offices will, but not always. All right, so what are these supportive measures? They are, again, can be offered as soon as the report is received. They can be offered to both parties or one or the other. They have to be individualized, like I said. They have to be free and that they can't cost anything. And then they have to be, quote unquote, designed to restore or preserve equal access to education, to protect the safety, or to deter sexual harassment. That language is probably going to be used to be limiting. And what I mean by that is the school is not going to be found responsible for violating Title IX by not offering or providing supportive measures unless that measure would have restored or preserved equal access, protected the safety, or deterred sexual harassment. It seems like most anything would fall under this protect safety. And I think that obviously as attorneys and as advocates working with survivors, that's what we're going to point to most often when we say we need this more supportive measure, and the reason you should implement it is because it is to protect the safety, or probably to deter sexual harassment, in the sense of I don't want this person to do this again to the survivor, so I want no contact to be allowed. It's going to be harder to show this restore, preserve equal access to education piece. That seems like a lot of words that don't mean a lot, but I'm sure they'll tell us eventually what they mean. Supportive measures are not punitive, right? They cannot punish one person or and not the other. They cannot unreasonably burden any other person. There's something interesting about this, the any other person. It does not say they cannot unreasonably burden the other party. I think the reason for that is that there isn't another party yet. That formal complaint hasn't been filed, so there may not even be a proceeding to which there would be parties. But because it says any other person, I think arguably if it's going to burden someone, even if they aren't the accused, the school won't have to provide the supportive measures. This is another, so supportive measures are different than remedies. And this idea of supportive measures, and yes, they can be provided to either party and they can be provided throughout the process and after. But the idea of these, I think, is an example of that shift from punishment, shift away from punishment, right? To cutting slack, letting college kids be college kids. The schools are not going to be allowed to punish a perpetrator in any way until the entire process is ended. It's going to be pushed to the end. And so obviously that's going to limit the accommodations that a survivor could ask for, or that they can ask for whatever they want, but that will be ultimately granted. So when we think of accommodations, some of the things we might automatically think of are now going to be considered remedies, and these are two different things. Remedy is provided to a complainant after a finding of responsibility. So after a formal complaint has been filed, an investigation has occurred, a hearing has been held, and the respondent was found responsible for at least one allegation, then the school can may provide remedies to the complainant, and these can be punitive. This is going to be like a one-way protection order. He has to stay away from me here. He cannot come to these buildings or this section of campus, or cannot be on campus after these kind of hours or when I am. He cannot use this library because I do. Those type of things are going to be remedies and can only occur after the finding of responsibility, which I think is going to mean it's going to be hard to get those type of things by any sooner. So, and I say that only if the individual schools interpret it that way. So when I say it's going to be, I'm saying that in the worst case scenario, you are certainly going to have schools who are willing to define certain orders as supportive measures and not remedies, but by and large, I think there is going to be a shift. So for supportive measures, that's going to be these mutual no contact orders that most schools have already moved to. And that's going to be the things they mention is that for security there, you can request that more security guards or cameras be put in a specific area of campus. It's not that security in the sense of preventing the perpetrator from being anywhere. The schedule changes and housing changes are that the person requesting the supportive measures can ask to have their housing changed, their schedule changed. It seems pretty clear that it's not going to be that they can ask that the respondent's class schedule be changed or the respondent's housing be changed. They can ask for an escort around campus if that's something that the survivor may want. And as advocates, you know, there's ups and downs to that. And then those extensions and those kind of class academic specific things. For the remedies, these are going to be the, like I said, stay away orders, stay away, things that restrict access to specific places or activities on campus. You can't participate on the debate team anymore, type of things. Do any of the advocates on the call have anything to add before I move on to the formal complaint process?
Hey, it's Becca again. I just wanted to reiterate a couple of things you said, just to kind of make sure. I know when I'm going through the regs, I like to kind of go back and just make sure that I'm reading it right. I wonder kind of what we'd also talked about earlier is about the unreasonably burden. That's also going to vary greatly about what someone would consider reasonable versus unreasonable. So once again, that might differ between who's making the decisions, what that looks like for each individual student and every single institution. So at the college level, if there is multiple different sections of a class, that may not be considered unreasonable to put them in a different class. So that's really going to vary in terms of what that's going to look like. I also want to make sure and reiterate, and Kendra mentioned this as well, that the complainant or survivor or victim, whatever language you'd like to use in the moment, can change their own schedule. So although that can seem very burdensome at the time, it's important to know that they can still do that, even if they don't want to, and they shouldn't be the one changing. But just be aware that that can happen if they would like to change that. That's also going to look very different on the smaller institutions versus the larger institutions at the K through 12 level, because there's different restrictions and ramifications of altering at the K through 12 level than the college level. So just being aware of those kind of different things. And like I said, Ohio has a ton of institutions, particularly higher education institutions, and it's going to look very, very different about what it would be considered unreasonable in some areas versus others. But the survivor still has the opportunity to change their own class schedule, to go to a different dining hall, to go to a different dining hall at a different time, or maybe at just different time generally if the school doesn't have multiple dining halls. So just all those kind of different things that a survivor might be able to do, and really looking at that safety planning that we do with survivors to make sure that they're feeling comfortable as they can be, particularly in that supportive measure before someone's found responsible. Once someone is found responsible, that's a little bit different, because they can at that point then be the respondent can be burdened once they've been found responsible for something. But for the supportive measures piece, just making sure you're doing that safety planning and keeping those things in mind about what the school may or may not be able to do.
Thanks, Becca. And another thing I wanted to point out, one way that perhaps we can use this this new kind of step-by-step process in reporting versus filing a formal complaint, and supportive measures versus punitive measures. I think we can use this to survivors' advantage when we have survivors who want to report only because they want some help or support. They don't maybe their primary goal is not to necessarily hold the respondent accountable in a punitive sense, or they don't want to report because they just don't want the respondent to know that they reported. They don't want to face intimidation or harassment, lose their friends, etc. We know all the reasons people don't report. But if there is a good thing about this report not triggering an investigation and the school being limited to providing these supportive measures, survivors in those instances may be encouraged to report, because you know, they can report just to you know, get an extension on an assignment or drop a class. That was always the case, obviously, but now it's very clear that this investigation is not going to occur. Respondent's not going to be involved at this early step. Okay, let's see. So now we're going to go on. So like I said, just to recap a little bit, a report is made or somehow the school obtains actual knowledge, and by the school I mean the coordinator, means actual knowledge of something that might be harassment. And then that triggers their duty to respond. So the first thing that's going to happen is they're going to respond. They're going to tell the victim these things we have here. This is the point where the survivor can ask for, request supportive measures, and then it's going to be up to, so then either the survivor or the nope, let me do the other thing, sorry, about reporting the harassment itself. This is different than the formal complaint. We're not to the formal complaint yet. This is just the initial, hey, this thing happened, and you know, this instance of sexual violence happened. Anyone can make this report. Doesn't have to be the person it happened to, doesn't have to be the survivor themselves, can be a witness, can be a friend, can be any other third party, can be someone who saw it, can be a professor, can be an employee. Anyone can make the report initially. And it can be done by any means. So, you know, this means that the school isn't going to be allowed to say, you have to use this online form to report sexual misconduct. And if you don't use our specific form, you know, we're not going to receive your report. Maybe even Morse code. So again, the report, however, has to go to a specific person. It has to be made to the coordinator to be considered an actual report. And this is what launches the school's duty to respond, not investigate. At that point, then, either the complainant or the Title IX coordinator can make the decision to move to the next step, and that's the formal complaint. This is what they call an official document. Likely, this is going to be one specific document at each institution that has to be filled out specifically and provided to the coordinator in order to launch an investigation. If a survivor provides a 20-page written written statement of what happened to them, what they want to happen to the respondent, how they've been affected, what they need, that's all still only going to be considered a report. At most, that's going to trigger that duty to respond and that duty to try to have a conversation with that person. Duty for the school to consider whether more steps need to be taken. It is not going to mean that an investigation automatically occurs. So while for a report, you know, they make it very clear you can send it by courier pigeon, you can mail it, fax it, email it. Here, that is not the case. In order for the formal complaint to be properly received, it's going to have to be the submission of this official document, and it's not clear. So I think here that's either going to, you know, it probably can be an online form or a hard copy form, and schools may require one or the other specifically, and that's probably going to be up to the school, but it is going to be only one way, one official document. When I say it can be filed only by the complainant or the Title IX coordinator, obviously that means then that if a professor or if a witness files the initial or submits the initial report of harassment, they can't then initiate the formal process. They cannot submit the formal complaint. That has to be the complainant themselves or the Title IX coordinator. And so it is possible that schools could take that to mean that it's always filed by the Title IX coordinator. And so what may happen is that the complaint, they discuss with the complainant what they want to happen. The complainant says they want to engage in the formal process, and then the Title IX coordinator fills out this document that launches the investigation. And And that would be probably okay. But what it also means is that in certain circumstances, and these are going to be, of course, these extreme cases where the coordinator decides that the the harassment is so egregious or the campus community is so at risk that it needs to that the perpetrator needs to be disciplined, then they can file the complaint even if the complainant does not wish to engage in the process. But that's going to be very, I mean, and that has always been true, but that's going to be very rare. Like I said, it can't be filed by anyone else, but in the K-12 context, a parent and guardian can obviously file that on behalf of their minor student. Again, this triggers the investigation, but I say schools' discretion to investigate because it's not necessarily automatic that this investigation is going to occur. Between the filing of the formal complaint and the investigation is going to be this kind of quasi, and I'm going to call it the dismissal step. So is the complaint going to be dismissed? Now, the complaint may be dismissed. The report may have been dismissed even before this, and there's nothing preventing that. So initially when the school receives the report that harassment occurred and they just read it on its face and decide that even if true would not violate Title IX or would not violate our policies, they can tell the survivor that off the top. But after the formal complaint is filed, they are going to have to consider whether or not they are going to pursue the investigation or they are going to dismiss the complaint. We'll talk about that in just a second. At this point, the respondent is notified of the allegations against them and of their rights of the process and can ask for supportive measures. Which again can be used in the sense that a survivor can make a report without the respondent automatically receiving notice. We knew that before, but it's really clear here. And it's not up to the respondent whether or not the formal complaint process goes on, whether or not there's an investigation. Except that, we'll talk about it in a minute, there is a little bit of an opportunity for the respondent to complain ahead of time about it going forward. And later we'll talk about the opportunity for informal resolution, and while both parties have to voluntarily agree to engage in that, obviously the respondent can try to stop the investigation from happening by requesting that informal resolution process. So anyway, the school discretion to discipline. So again, even if no formal complaint, so even if the complainant does not decide they want to pursue this formal process, the school can still initiate the grievance procedure, which would start with the investigation, if they believe the discipline needs to be imposed. Like I said a minute ago, I think this is going to be a rare occurrence, but the opportunity is there. One of the reasons I think it's going to be rare is that what this would mean is that the school is voluntarily choosing to do more work in going through this entire process when they are not required to do. They have a lot to do, so it's probably going to be pretty rare. But, and of course, what they're going to say is that they are trying to, in all instances that possible, follow the survivor's wishes, which I think is a good policy. But I think there are certainly times that a survivor is not sure about pursuing a formal complaint, but arguably there should still be some disciplinary measures taken because a person needs to be immediately taken off campus or something. Just a second here. Do the advocates have anything to add to that point before I move on to the next kind of quasi step about notice to the new things that will be notices that will be provided and the possibility of
Sure, so I can talk a little bit. There's just kind of one thing I want to make sure and highlight, particularly in relationship to K through 12. So we've already said that in K through 12, the parent or guardian has the ability to file the complaint. So as an advocate or as an attorney, just being very clear with who you are there supporting and or representing, so whatever your capacity is. So whether you are representing or supporting the complainant, the parent / guardian, the survivor, whoever that person is, to make sure that you know what your role is in that, and also that the individuals or the family that you're supporting. I know that can get kind of murky, particularly in K through 12, although we've also seen that quite a bit in the college cases as well, that parents may want to be more involved. So just to kind of bring that to your attention, to make sure that you're familiar and kind of aware, and make sure you're sharing with the family who the complainant is and who you're representing, and or who, if you're an advocate, who that survivor is that you're working with, just to make those roles very clear. So that's the only thing I really want to kind of make sure I highlight there, to make sure that people were kind of thinking that through. And that's something we've seen before, so nothing too new on that. Just like to make sure and highlight that for everyone.
Thanks, Becca. All right, so let's say that the formal complaint is submitted either by the complainant or the Title IX coordinator. Now we see, and this is new, all of this language here is new. Arguably, it was always the case that a school could dismiss a complaint if it didn't meet the, if it wasn't sexual harassment, they could decide they're not going to investigate sexual harassment. But they make it really clear here, and make this dismissal decision into a process in of itself, another step in the process. So there are instances where a school can dismiss the complaint of sexual harassment before or without providing a meaningful response or investigation in certain cases. In fact, they have to dismiss the complaint if what is alleged does not describe conduct that meets the definition of sexual harassment. So they cannot even pursue an investigation if they look at the complaint and say, if it's true, is not going to be sexual harassment. Sexual harassment, if they determine that sexual harassment did not occur in the school's education programs or activities, or interestingly, did not occur in the United States, what that does for study abroad programs, service project programs, is interesting. Arguably, they cannot touch those things, which is problematic, but we'll see how that goes. And then again, this school education programs or activity piece is really limiting language. And if the school chooses to interpret that language as literal, in the sense of it has to have occurred at, in the classroom, at a study hall, in the dorm rooms, and if the parties were at some party off campus, way off campus, they may argue that that's not an education program or activity. In those cases, the school can still address the conduct and can even discipline the perpetrator if they're ultimately found responsible, if the conduct would violate state law. So if someone alleges sexual harassment and the school looks at it and says, yeah, that's not harassment, but they definitely did assault you, right? Like, we're not going to find that there was the components of this to make this a sexually oriented crime or event, but this person did punch you, so we're going to say this was assault. That's obviously a criminal offense in, I hope, every state law. So if that's the case, the school can address it, or if the alleged conduct would violate this code of conduct. That's the school specific code of conduct, different at every school. Most code of conducts are going to include language about if the behavior is criminal offense in the state law, so that assault would automatically be addressed by the code of conduct, can automatically be addressed by the code of conduct. And then there are going to be other, and every school is going to be a little bit different, but there are going to be other instances of conduct that may not be, they may determine it's not sexual harassment, doesn't meet that really strict definition of sexual harassment, wouldn't necessarily violate a state law, but would violate code of conduct. Maybe this person didn't sexually harass you, but they definitely did engage in plagiarism when they were using your work in class. And that's a code of conduct violation. Again, this is another thing that was always true. Schools could do that, some more than others would, but it spells it out here that that's a possibility. And it also makes it clear, though, that again, they can address the conduct and then and through their code of conduct policy, but it cannot be under the Title IX process, which means if there are sanctions or there are specific disciplinary measures that apply to a finding of responsible in the Title IX process, but that are not possible in the code of conduct process, I don't know what those would be, though arguably that could occur. Those cannot be put on the perpetrator, even if they are found responsible for violating the code of conduct, because it wasn't sexual harassment. So that's when they absolutely have to dismiss appeal. They have no choice. They may think that what occurred was horrific. They may think that the impact on the survivor is extreme and traumatic. But if those things are true, they cannot pursue the investigation anyway, at least into those allegations. They have an additional opportunity to dismiss the complaint. So discretionary is up to the school. They can dismiss an individual complaint in these instances. So, and in these instances, they could decide to dismiss the complaint entirely, even though it's not mandatory, or they could dismiss some of the allegations. So we're going to be familiar with this in that typically this would occur, I think at most schools after the investigation, when the investigation report is written, the school will say, we looked into all of the allegations and we decide that we are going to pursue a hearing on allegations 1 through 4, but in our investigation, we didn't find enough evidence that it's even possible that, you know, on this July date, there was an instance of sexual harassment because we found that the two weren't in the same city. So we're not even going to let that one be addressed at the hearing. We're dismissing that. Now that's going to occur or can occur up front before the investigation. In that, and so we might see here maybe just one or some of the allegations going on to the investigation process. If the complainant gives written notice to the Title IX coordinator that they want to withdraw the formal complaint that they've already filed, then it's up to the school whether to dismiss it. Some important things here. Again, it has to be given to the Title IX coordinator. Just someone in the Title IX office is not going to be sufficient. Just emailing the investigator is not going to be sufficient. It has to be to the Title IX coordinator and from the complainant. So the complainant probably can't say to the investigator, please tell the Title IX coordinator when to withdraw. They're going to need to get that information to the Title IX coordinator themselves, and they're going to have to put that information in writing. So it isn't going to be enough to call them up and say, I want to just withdraw this complaint, I don't want to go through with this anymore, it's going to have to be written notice. Some schools then may require a specific document be signed. They may, schools may likely come up with some, waiver of the process and have the complainant sign it at that point. Or arguably an email would suffice, right? It is in writing of the intention to withdraw. Even if that occurs though, and so, work with complainants here and that nothing else is sufficient, they need to write it down. The best thing to do if there isn't a specific form, yes, email would probably work, but my advice would be obviously to write it out and use the specific language that's here is, I am providing written notice that I want to withdraw the formal complaint I filed on date against date, period. So that there's no wiggle room in there. But keep in mind, again, this is one of the discretionary instances. So even if all of those things do occur, the Title IX coordinator could say, yeah, no, we still have to pursue this under the Title IX process because of the nature of the conduct or whatever it may be. Maybe they think the complainant is giving that written notice under duress or that the perpetrator is dangerous. Again, I think this is going to be rare. It's probably going to be the case that if this is submitted, if a withdrawal request is submitted, then they're going to probably dismiss the complaint. The school can dismiss a complaint if the respondent is no longer enrolled or employed at the school. This is new in this way. So we certainly have had Title IX cases, you probably have seen them, where the respondent is not currently at the school. Maybe they went there last semester, but they are taking a semester off when the complainant feels safe to report. And the school can, obviously launch an investigation if it gets to that point. Not anymore. That respondent could have been or has to have been enrolled. They have to be there as a student when the complaint is filed. Same with former employees. If they taught last semester but didn't this semester, they're not going to be able, or they can choose not to pursue an investigation. That's not saying that they can't. So it's not saying that they can't say, yeah, that student should still be held accountable, or yeah, but what that professor did is just not acceptable under our policy, and we're going to make sure that the complainant's wishes of pursuing this is met. But they can, and so that's probably going to be very school specific or maybe even case specific, but depending who the players in the game are. But they may not have to pursue an investigation, even in the instance where, say, a professor is accused of sexual violence against a student. If they're not there anymore, the school doesn't absolutely have to investigate. And then there's this kind of ominous that the school can decide to dismiss the complaint if specific circumstances prevents the school from gathering evidence that they would need in order to further the investigation process or the hearing process. This is problematic potentially. What we would assume this would mean is, I don't know, they can't find the perpetrator or any witnesses. They can't reach more often it would probably be they can't reach the complainant. The complainant stops participating in the process without filing that written notice of withdrawal. They just don't answer the calls anymore or something. Arguably it could be that they can't, they're not allowed to get certain records that would support the claim. Few things to think about here though. What does gathering evidence mean? So is it sufficient that they can't get one central piece of evidence, or do they have to not be able to find any evidence? Is it, so in that case, we would hope schools would say, all we need is this complaint and the statement of the complainant to keep going. If we don't find any other evidence, then we'll assess the credibility of that statement and decide whether or not we can find the respondent responsible just based on that. Maybe it's going to be harder to find them responsible just based on that, but we will carry on. Or is it that they just can't find this one thing they think they need in order to keep going, and so they can decide to dismiss? And my biggest concern with this language is, what I would not want to see happen is that this encourages witnesses or respondents to refuse to participate or speak to investigators. Now, most school policies are going to have some sort of language in their policy about how it may be a violation of the code of conduct to outright refuse to participate in a process if you are a witness. But every school obviously doesn't have that, and neither party has to participate. You can't force a respondent to respond to allegations against them. That's not in their own interest. But so the concern would be, is that going to be sufficient to allow the school to just drop the complaint? Because we wouldn't want to see just the strategically one party advising witnesses or themselves refusing to cooperate so that it gets dismissed. When we kept saying discretionary dismissal, so it's up to the school whether or not they're going to dismiss the complaint before the investigation at this point. The way the language is in the regulations is that in all of those instances, dismissal is the presumption, which means the school should lean toward dismissing in all of those cases. Unless it's a special case, they, only in a rare event would they keep going. And the terms they say is only if they think dismissal would be inappropriate. I would argue that dismissal would be inappropriate in most all cases, but I think that schools could argue that one of these instances was met, and therefore the dismissal could also be appropriate. And because dismissal is presumed to be the kind of the go-to in these instances, we're gonna throw it out. Both parties have the right to appeal a dismissal decision. That's all the regulations say, which means I would presume then that if a school throws out a complaint and says, we're not going to look at this, a complainant could appeal that and say, you made the wrong choice and here's why. And this needs to be addressed. What I don't know is whether or not it follows then that the decision not to dismiss could be appealed, and I would presume it to be true that a respondent can appeal the decision not to dismiss, even when there was no real discussion or question of dismissal. So in an instance where the alleged conduct, if true, would absolutely be sexual harassment. It's a case of forced sexual penetration. And so if true, that would absolutely be violative behavior. Is there an inherent right at this stage, before the investigation is even launched, for the respondent to appeal the decision not to dismiss? So the school doesn't ever come out, in the instance I'm talking about, The school doesn't ever come out and specifically say, we've considered X, Y, and Z and have made the determination that we will not dismiss this complaint. Rather, they just didn't. They just did start the investigation or did accept the complaint, because now the respondent is getting emails about the investigation. Can they appeal that? If yes, then I think we're going to see that in most every case. What's important in this appeal is it's treated like the appeal of the ultimate hearing decision. So there is an opportunity to respond, and then there is a decision to be made, and that decision cannot be made by the Title IX coordinator themselves. I think in practice, this is going to drag out the timeline, obviously. If there are if we have to wait for the school to make a formal decision about withdrawing a complaint and then wait to see if there's going to be an appeal and respond. But that does remain to be seen, and maybe it'll be cleared up, but that might be an instance where it'll be cleared up by specific language in school policies, but we will see. Do you have anything on this, advocates?
You know I'm going to all the time. So I want to make sure I mention here just how important location is in these regulations. So there's a lot of conversation and a lot of language in the regs about the location of the incident. So just make sure and bring that to your attention. And also what this might mean in terms of the complications. And I'm not really going to provide any answers here, but just to bring to your attention for those patterns of behavior, because sexual harassment specifically includes things like stalking and intimate partner violence. Those patterns of behavior that may happen on campus, off campus, in the US, not in the US, being aware of that and that is going to impact what that complaint may look like. So that formal complaint may look a little bit different than the survivor may even want it to because of the location piece. So as we know with those patterns, it might be happening on campus, might be happening online, it might be happening off campus, just being aware of that. And then the last thing I wanted to make sure and mention is something that Chelsea actually brought up, is just how important education to the students, to the staff, to the family members about the various different pieces. So we've used a lot of language already today, and we're only in part one of this conversation. So particularly the difference between a complaint, a report, investigation, right? So all those different things are varied, right? So in something like a K through 12, making a statement to an employee, that might be a report, which then can end up in a formal complaint very easily because the K-12 responsible of who's considered mandatory in terms of reporting. Another thing in terms of the college for that very same type of report, that might only be able to be given directly to the Title IX coordinator, right? So just being very clear with the survivors, with the students and the employees, what the differences are, right? That a report may not actually be a formal complaint and that a report may not lead to an investigation, so that they know and they can kind of take that ownership over what they want to do and how they want to proceed.
Thanks, Becca. And to that point, I think it may be a good idea, because of the central role of the Title IX coordinator in these regulations, to just always make sure everything gets to the coordinator, even if you're not sure if this is one of the things that's required. You know, copy the coordinator on all emails, send a copy to the coordinator of everything you send to anyone else in the Title IX office. It may be excessive and annoying to the coordinator, but you're covering your bases. And then I wanted to make a point that I hadn't yet. I keep saying there's K-12 cases and then there's college cases. It's obviously not just colleges, it's any post-secondary institution, and that's going to include your tech schools and things like that. So this does not just apply to traditional four-year limited liberal arts schools or to community colleges. It applies to all post-secondary institutions receiving federal funding. All right, and the last thing I want to talk about today real briefly is that the new regulations do make it a possibility to informally resolve complaints of sexual harassment. Previously, this wasn't allowed for behavior that would be considered rape in like a state law, but they're allowing it here for anything. But of course, both parties have to voluntarily agree to this informal resolution. What would probably happen is that one or the other would propose it, and then the other would get to answer whether or not they want to do that. Though what I could see happening here is that the school just makes the practice of before the investigation occurs, the parties are given notice of the opportunity to request informal resolution, and there's some sort of form they fill out that says yes or no, and then they can form that fill up. They can change their mind anytime, of course, but there will probably be some sort of form where they check, yes, I would like to voluntarily do that, or no. Obviously, voluntarily means that no party can be forced or threatened or required by the school. So the school can't say, in this type of case, we are always going to informally resolve the allegations. When the informal resolution is chosen by both parties, the school then will provide a person named a facilitator who will facilitate this informal resolution process. This is going to be like a mediation process. So this person is the facilitator, is going to be like a mediator. And we're going to talk all about the training next time for all the decision makers, but like all of them, they are trained to be unbiased. Specifically, again here, don't assume perpetrators did perpetrate because of their gender. Don't assume because this person is a male athlete that they did the things that this female identifying survivor has alleged. And then even if the informal resolution is chosen by both parties, the school still has that responsibility to provide notice of all of these things. So they still have to tell both, they still have to tell the respondent what the allegations are. They still have to provide notice of the rights to throughout the process to both parties and how to do certain things, or to then seek those rights, seek the enforcement of those rights. They have to provide notice about the information about the confidentiality of the informal process and how to withdraw from the informal process. Again, either party or both parties can withdraw from the informal process at any time, even at the last minute, meaning until that agreement is reached and signed by both parties, the informal process either party can walk away from the table and say, this isn't going in a fair way and I wish to pursue the formal process. Once the informal process is withdrawn, that triggers the formal process. So it's going to be presumed that that formal process takes over, that investigation includes or occurs, unless the complainant also then provides that written notice to the coordinator that they also want to withdraw from the formal process, but that's going to be a separate request. And again, then it's going to be up to the school. So like I said, today we looked at several of these points in the new rules. Next time we're going to look at some more changes, and specifically process changes. And then at our last instance, we will have a Q&A and wrap up. So please come next time because we have only begun kind of dissecting this piece by piece. And one overarching theme that I would say to advocates is these regulations are wordy, lengthy, obtuse, you choose the word, they're complicated. There's a lot here to pick apart and that could be used against survivors. Sure, there are opportunities to use to the advantage of survivors, I think, but there are also many opportunities for others to use these regulations to harm survivors. So I know that advocates always consider suggesting to a survivor that they have an attorney in a Title IX case that's going to go to a hearing, but at this point that is centrally important. It is probably true. It is true that every survivor is going to need the opportunity to have their rights protected by an advocate, an attorney advocate, in addition to the advocate. Becca, do you have anything, I skipped over, do you have anything about the informal resolutions or anything else that you think advocates should think about before we open up the Q&A?
I think in the interest of time, we had a couple of questions come in, so I want to go ahead and make sure to get those questions answered. I'm sure there's many things that we could talk about especially in terms of the informal resolution and really everything else, right? So we've only spent 2 hours on this. We could spend a lot more time on all these subjects today. So I'm going to touch base on a couple of questions, and Kendra, feel free to jump in whenever. So the first question I want to make sure and address right away is we are going to make this recording available to anyone who is registered. So just so you all know, all this will be available. If you afterwards, we'll make sure and have it so you can log in and and access that recording. In terms of the next webinar, so we're going to have one next week, Monday from 1 to 3, just like today. Then we'll be skipping a week due to Memorial Day. It'll also be Monday at 1 to 3. We'll be sending out that registration information sometime after this webinar to anyone who is registered for this webinar. So please make sure if you're interested, register for that next one. You will have to register for each one. Registering for one doesn't register for you for all of them. So now that that's out of the way, there's a question about appeals. And we're going to be addressing that next week. So I would highly encourage those that were asking about appeals to tune in next week. We'll be addressing that. We want to kind of stay focused the questions on the ones for this. We also had a question about lawsuits and the impact of some entities that might be suing to keep the rules from taking effect. Given the swift turnaround time, we are assuming that schools are beginning to prepare for the regulations and will begin to implement until there is a lawsuit saying otherwise. So please be aware that that might be happening regardless of time frame, that there might be a lawsuit coming forward from one or multiple entities in the coming months. So be aware of that and be on the lookout for it. We are moving forward with these so that you all are aware of what the regulations say now, but know that any lawsuits that come forward might have an impact on what these regulations are going to look like moving forward. Kendra, did you have anything to add to that?
Yeah, just that I think you're right. I think that we have to prepare for as if these are going to take an effect at all schools on August 14th. Another reason that the lawsuits may be delayed is there are certain claims, certain types of claims that are only going to be able to be brought by any parties once something has gone wrong, right? So once somebody's rights have been violated, then the lawsuit will be launched. And so that means that the entire process is going to have to go through in at least one case for certain claims to be brought. When and if certain lawsuits are brought, the impact could be immediate in that a court could issue some sort of stay on using the regulations until the constitutionality of it is determined by the court. But also just the filing of a lawsuit may not necessarily do that. It may be the case law that comes out of a lawsuit that is the impact that we have to consider. So what did that court say and how does that change or add to the regulations as we read them thus far?
Great, thank you. Another question that came in is, do college responsible employees still have a responsibility to report incidents to the Title IX coordinators under the Title IX regulations, or is that up to the college?
Yeah, so under the regulations, the only duty to report an instance of sexual harassment falls on that Title IX coordinator. So arguably, I think under these regulations alone, there's no duty to report for professors, for other professionals, for staff members, for coaches. State law may be different and college-specific policies may be different. But under these regulations, there's not any duty imposed.
Thank you. Next question is, can you provide more information on how online, like social media or text, sexual harassment looks under the new regulations?
Yeah, so that's going to be treated just as any other instance of sexual harassment. And so that is included as possible sexual harassment. But again, in order to meet that standard, it's going to have to be both severe and pervasive and objectionably offensive, and it's going to have, you're going to have to arguably show that it has had the effect of denying the survivor to a loss of access to their education. So that high standard, so yes, that can be harassment, and I think we have been seeing up to this point schools addressing that as harassment, as sexual harassment, but that heightened standard is going to apply to that. And also, I would say this idea of free speech is central in colleges is also going to apply to allegations of harassment online or social media. Even if it occurs, there's no question that it occurs between two students and that they're both using, say, school laptops on campus. So the question of location, the question of jurisdiction is not a question. What is going to be a question is whether or not the school finds or the respondent argues this can't go forward because I was only using my free speech when I did those things. And so we're gonna have to see how this argument of free speech pans out.
Great, we had a clarifying question I just want to make sure and address real fast in regards to the future trainings. We are going to be emailing out the information to anyone, or the registration information for the next ones to anyone registered today. So you'll be getting an email about that relatively soon. And then we'll also be having it available on the website as well. So you can log in on the website and access that training registration as well. But anyone who's registered, keep an eye out for an email from us with that registration information for the next ones, just to make sure that that was clarified. We have about a minute left. There was a question, Kendra, if you want to try to address this real fast. What if someone was assaulted by a student who goes to a different school? Can the survivor still use the other school's Title IX process to report?
So under the regulations here, it needs to be between two students. Now, how that plays out going forward remains to be seen. Is that one of the things that a school policy can expand upon, right? So can a school say, we are going to look at things between reports between one non-student and one student? That's a question, though I would say if we're looking at the regulations literally, the answer is no, with the caveat of what I think we could see is that the school says you can't use the Title IX process to address that, but it can be addressed in some other code of conduct process. It just can't be, you know, it can't be this specific process. And so if there are disciplinary actions tied specifically to the Title IX process, those aren't going to be able to be implemented in that instance.
Great. Well, it is 3:01, so we want to make sure and be cognizant of everyone's time here. I'm sure that there will be more questions, concerns, comments kind of moving forward. Like I said, I encourage you all to check in on our next webinar on Monday, where we'll talk about kind of the next group of changes. And please feel free to reach out with any questions or concerns to us. We're happy to kind of help address and answer those as best we can. Moving forward. But thank you all so much for your time and your questions and comments throughout the webinar today.
Thanks for coming, everyone. Please come next time.